Minister Poleis.
Thank you very much, Honourable Speaker, Honourable Prime Minister, Honourable Leader of Opposition, Honourable Deputy Prime Ministers and Cabinet Ministers, Honourable Members of Parliament and the people of Fiji. We started off on a very serious bill this afternoon, Mr. Speaker. So before I participate in that bill this afternoon, I know that I have about 7 minutes, I've been told. Let me firstly take some time, Mr. Speaker, with your leave. I know that we have had some special mentions this week at Parliament with birthdays of two of our members of Parliament, including the Honourable Prime Minister, the Honourable Prime Minister and the Honourable Minister for Home Affairs and Immigration. Not to mention the acknowledgement and congratulatory remarks made by Honourable Baniwalu to the winning QBS Dean's team, and acknowledging the Natambua for the first time, and historically Natambua reached the Dean's final, which was an achievement on its own. So we congratulated, I think the Honourable Prime Minister also congratulated the Natambua team and its management. Today, Mr. Speaker, I want to acknowledge and congratulate Suva Grammar School for their feat in winning the 4 netball titles that was available in the girls' grade, under 14, under 15, under 17, and under 19, which is a clean sweep. For Suva Grammar in 2023. I don't know whether it is happening for Suva Grammar again, but I think I'll leave that for then. Mr. Speaker, on the 3rd of March 2021, I wrote an opinion. Soon after, I think, this amendment took its passage through Parliament in February, if I'm not wrong, of that year. I mentioned that the Anti-Corruption Division of the High Court and the Magistrates Court was not warranted in 2021, and I don't see any significant reason why it is even warranted now. And I will explain, Mr. Speaker, to the benefit of this House, the reason why I say those comments. Firstly, Mr. Speaker, when that bill went into Parliament, or came through Parliament in 2021, I suspected that no one who really practiced in the criminal corridors was ever consulted. FLS was not consulted, which was at the time the only body that a lot of lawyers were a part of, and not to mention there was a separate criminal bar that was not formally an association, but we meet quite often, and normally across the coffee house at the FBC building. And so because it didn't have, Mr. Speaker, the wide consultation that this bill has had in this House today, as explained by the Honourable Attorney General, that time, in my view, it lacked the energy it needed for that bill to take its course through Parliament in 2021. As I mentioned, and as alluded to by the Honourable Attorney General, this bill has had consultation. Fiji Law Society has been consulted, practitioners have been consulted, and various stakeholders have also been consulted before government decided to bring this into Parliament. FICAC, of course, was established as a decree in 2007, Honourable Speaker, by Decree number 11. And it commenced on the 4th of April of 2007. So contrary to the belief that is held by the two previous speakers, that we did that because we ratified the Anti-Corruption Convention by the UN. The UN anti-corruption ratification came in 2008. We started FICAC in 2007. What was really the reason, Mr. Speaker, of the establishment of FICAC as an anti-rot body was it was seen to be a flagship of the Bainimarama government at that time. Because as you remember, Mr. Speaker, at that time it seemed to have been one of the things that they have to check off, that they have now satisfied as one of the reasons why the overthrow of a properly elected government was done in the previous year in the month of December. And later on, 2 years later, in 2009, they threw away a properly consulted Constitution of 1997. Yet, Mr. Speaker, even way back then, in 2007, they didn't seem it fit, even at the time, to establish the accompanying specialized courts. It took the Fiji First government 14 years, almost 14 years, later, to finally decide, wait, hold on a minute, we've got an anti-rot body. We need anti-rot courts. That's what happened in 2021. Mr. Speaker, 14 years later, it is flabbergasting for the government in 2021 to cook up an anti-corruption court to supplement the work of the anti-corruption body that they established 14 years previously. Mr. Speaker, thank you. Why do we need specialized courts? What usually triggers a country to set up these specialized courts? And we have specialized courts. The two previous speakers have alluded to them, Mr. Speaker, family court, employment court. We also have the juvenile court. But what's peculiar about these courts is when the enabling issue legislation is enacted, it brings the courts with it. That's what happened, and that's what didn't happen in this anti-corruption regime that we are talking about today. But one of the reasons why I think specialized courts are usually established is because there has to be a bona fide reason, not just reason, a bona fide reason why it should be established. For example, one of the reasons why specialized courts are established is because a government might find that there is an increase in offending of a type of offense or similar offenses of similar nature. For example, when bills are introduced, when the bill to introduce the Anti-Corruption Division of the High Court at the time in 2021, Fiji was facing a horrendous statistics on sexual offenses, rapes, indecent assault, and even, might I add, domestic violence against women, young girls, and the vulnerable of our society. So, the second reason I wanted to express here today, Mr. Speaker, is when there is a need for specialized courts, there has to be trainings that has to accompany the setting up of those courts in respect to judges, staff, prosecutors, and all the players that are involved. And again, for example, when a child complainant in a sexual offense is giving evidence, there has to be special mechanism built around the courts to ensure that a degree of sensitivity is afforded to those who are participating in the trial. Special playrooms, for example, Mr. Speaker, here in Suva, have to be set up so that young victims are able to be accommodated next to their best environment when they are giving evidence. Other issues like recordings in camera or proceedings in camera and separators to stop the line of sight from victims to see their perpetrators. These are all things that specialized courts have to go through.
Could you round off?
Thank you, sir. The long and short answer to this, Mr. Speaker, is that there is no justification for the establishment of anti-corruption division of the courts. and I say this out of experience, Mr. Speaker, when someone, for example, from Rakiraki is charged fresh by FICA, that person has to be taken to Mba. If the Mba magistrate is not sitting, all the way to Lautoka, just for a 5-minute appearance. Who does it cost? It costs taxpayers because they have to be transported all the way to Mba. Mba is not sitting, all the way to Lautoka. Nandi, for example, Mr. Speaker, if someone's charged in Nandi, all the way to Lautoka magistrate, who is authorized to sit as anti-corruption magistrate, not there, all the way to Mba. It costs to set up these specialized courts. And for this reason, Mr. Speaker, these offenses are not new. They've always been there in the penal code, in the prevention of bribery offenses. Always been there. Nothing special about these cases. They can be prosecuted like every other offense. And so there is no reason why, Mr. Speaker, the anti-corruption division of the High Court and the Magistrates Court should be maintained. It should be returned back as normal. All the magistrates and the judges can deal with them and also would be able to accumulate the experience that is needed in their own personal development as judicial officers. I support the bill, Mr. Speaker.
Thank you. And now offer the floor to the Honourable Leader of Opposition.
Thank you, Mr. Speaker, sir. The real lawyers have